Yeah, Councillor Dave Gaskell, I second that.
Thank you very much. Any declarations of interest? Councillor Gaskell?
None from me, Chair.
Councillor, declaration of interest? Thank you. Okay, welcome everybody. Councillor Adrian Cartwright, Councillor Dave Gaskell. You can't hear me? Is it on? Okay, is that any better? Oh, I can hear the echo. Oh, yeah, thank you. I'm Councillor Adrian Cartwright, Councillor Dave Gaskell, Councillor Caroline Phillips. Okay, we have a legal clerk, Ed Bostock, and James Chadwick's the legal officer. Okay, Licence Authority, staff's Nikki Goldensmith. And we have the applicant. Okay, thank you. And objectors, yes. Okay. Right. Have all parties received a copy of the agenda for today's hearing? Yeah. Okay. Are there any preliminary issues that anyone wishes to raise?
I have some plans which I'd like people to refer to. Is this the time that I offer?
Not yet. When you come to speak, you can do that. Thank you. Okay, this hearing is in respect of the aforementioned application for a premise licence. I would like to invite the licensing officer to introduce the report.
Good evening, I'm Nikki Goldensmith. I'm the Licensing Officer for West Northants Council. We're here this evening to consider a Licensing Act 2003 application for a new premises licence for the Vault Cocktail Lounge based at 130 Watling Street East in Towcester. The subcommittee is asked to determine the application for a premises licence in accordance with Section 18 of the Licensing Act 2003. Watling Street East is a former bank on the High Street of Towcester and is currently under a planning application for a change of use. On the 20th of March 2025, an application for a premises licence was submitted by Mr Anthony Walker and accepted as complete on the 20th of March. The applications for the sale of alcohol is as below: Monday to Sunday from 11 till midnight, and then live music from Monday to Sunday 5 till 11:30 in the evening. Also recorded music both indoors and outdoors on Monday to Sunday from 11 till midnight, and the opening hours from Monday to Sunday 11 till midnight again. And the full application is submitted as Appendix A, which you can find in your packs. Amendments were made to the timings following discussions with Mr Anthony Walker on the 24th of March to increase the opening times as below. So now from Monday to Sunday from 11 until midnight. And this was to allow for drinking up time after the sale of alcohol ends at midnight. Consultation was therefore restarted and the relevant authorities were updated of this. And the amendment request is submitted as part of Appendix B in your packs. Further amendments to the timings and conditions were made following discussion with the Environmental Protection Team and the applicant, Mr Walker, and these included restricting the access and use of the outdoor courtyard area to 11 till 11 at night, Sunday to Thursday, and 11 till 11:30 Friday and Saturday. Recorded music was to be played only at background levels and speakers turned off in the courtyard every night by 11 o'clock at the latest. Live music was only to be indoors and no use of the courtyard would be allowed, and doors and windows were to be kept closed. Copy of the proposed conditions were submitted as Appendix C in your packs. The proposed premises sits within the High Street of Towcester, where there are a number of other licensed premises. On the same side of the High Street, there are 4 licensed premises that already back onto residents that were built as part of the redevelopment of Moat Lane. The first is the Rice Bowl. This is a Chinese restaurant, and their current hours for the sale of alcohol is from 12 to 11:30 Monday to Thursday, and then 12 till midnight on Friday and Saturday. There is no provision there for live or recorded music. The second is the Brave Old Oak. This pub and courtyard at 104 and 106, which you can see on a map in your packs, on Watling Street East, also have the following hours for sale of alcohol: Sunday to Wednesday, 10 till midnight, half past midnight, sorry, Thursdays 10 till 1, and Friday and Saturdays 10 till 2 in the morning. And they also have provision for indoor live and recorded music from Sunday to Wednesday, 10 till half past midnight, Thursday and Saturday, 10 till 1. In addition, they also have 30 minutes added to their opening hours beyond the sale of alcohol in order to allow for drinking up. The third premises is an Italian restaurant which has a courtyard. They also have sale of alcohol, which you can see below, 11 till 11, Monday to Saturday, and 11 till 10:30 on Sunday. And finally, the fourth is the Plough, another licensed pub on Watling Street, number 96, and their sales of alcohol is Monday to Saturday, 12 till half past 11, and Sundays, 12 to 11. And they also have provision for only indoor, live and recorded music from Monday to Saturday till 11 o'clock at night, and Sundays, half past 10. When an application for a premises licence is submitted, the applicant must display a blue notice at or near the relevant premises and advertise the notice in a local publication no later than 10 days after submitting the application. Consultation runs for 28 days from the day after the application is received, and this gives interested parties and responsible authorities the opportunity to make representations in relation to the application. On the pack, you can see on my report that we had the responses from the responsible authorities. There was no response from most of them. The only two we did get no objections from, but with potential conditions to be added, were from Environmental Protection and from the police, and they can be found in your appendices. The additional conditions that were agreed between the police and the applicant, as I mentioned, were in Appendix D. We also have received objections from members of the public, and these are attached as Appendix E. The relevant areas that are pertinent to the licensing objectives have been highlighted in yellow. A map of the location of the premises, proposed premises in relation to the nearby residences and other licensed premises is attached as Appendix F. The applicant and interested parties submitting representations have been invited to attend, of which most of you are here. At the end of the consultation period, the licensing authority must hold a hearing if relevant representations are received, unless the authority, the applicant, and each person making the representation agree that a hearing is unnecessary. It must take such steps as it considers appropriate for the promotion of the licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The steps that the subcommittee today can take are to either grant the licence, subject to conditions as appropriate, if considered necessary to promote the licensing objectives, to exclude a licensable activity, to refuse to specify a person in the premises licence as the premises supervisor, or to reject the application. That concludes my report.
Thank you very much. We're now going to hear presentations from each of the parties. All parties will have an opportunity to make their presentations later in the hearing. At the end of each presentation, there'll be an opportunity to ask questions. Please keep the questions only on what you've just heard. Okay, I'd like to invite the objectors to make their representations. So, Mr. Bollen, if you're here, please.
Well,
Absolutely fine. Please.
Does that sound okay? Okay. Good evening, everyone. My name's Colin Clayson. I'm the MD of Clayson Country Homes, who built the surrounding award-winning Moat Lane regeneration scheme, which is now an established residential community. I would like to strongly object to this licensing application before you for a bar use at 130 Watling Street, Towcester. The Moat Lane area was previously very run down, and the local authority, South Northants Council, were one of the key agents for change in promoting its regeneration in and around 2014. Surely it cannot be appropriate for the same local authority who granted planning permission as they did for residential homes and apartments at Moat Lane to then allow an application of this nature to be approved in such close proximity to what has now become a well-established residential community, which was the original intention of the local authority in regenerating this area. The principle of putting a bar use with both live and recorded music and an outside space in the middle of a well-established residential area is completely unacceptable and totally incongruous with its existing environment. As you can see from the images distributed, there are many residential uses in very close proximity of the proposal. In fact, the rear courtyard of 130 Watling Street is only 15 metres to the rear of 31 Moat Lane and their garden. This is particularly pertinent when you think that live music can reach noise levels of 120 decibels when the legal limit for noise in close proximity to residential areas should be a maximum of 55 decibels, which in itself is very loud. The Moat Lane regeneration area, which is predominantly a residential scheme where I have sold flats and houses in good faith to purchasers whose quiet enjoyment of their homes is now severely in jeopardy because of this insensitive proposal. I'm very unhappy about this, as it is totally unfair to my purchasers, many of which have asked for my help in trying to get this proposal stopped. This proposal is causing much upset to the residents in the local area and would create long-term harm to the environment their homes are located in, and would be completely unjust to them to take away the peaceful existence they currently enjoy. This proposal will also prejudice the flats and the shops in Whittons Lane. It is a mixed-use scheme of residential and commercial uses, which we have avoided letting to any noisy or antisocial use classes, such as this proposal, to protect the integrity of the largely residential area. The increased noise they will be subjected to and the potential antisocial behaviour this proposal will create are totally unacceptable, and I object in the strongest terms. Has a site visit been undertaken? I would suggest that before any decision is made, this application is deferred to allow a site visit of the residential area of Moat Lane and Whittons Lane. If you, as decision makers, visit this area one evening, you will see how quiet, peaceful and tranquil it really is. In particular, a site visit would highlight the peacefulness of the area to the rear of the residential dwellings and flats adjacent to the rear courtyard of the proposed bar. My solicitor has also confirmed to me that this building has no legal rear access over our retained land, which is in the grey colour, and therefore cannot achieve a rear fire escape. This in turn would create a major safety issue in cases of emergency. I object to this proposal in the strongest terms, and thank you for considering my comments.
Thank you, Mr. Clayton. Anyone have any questions?
Thank you, Thank you, Chair. The residents that you've been in charge of, the ones that you're responsible for, what quality of building standards are they? Flats? Are they 2-3 storey high? And do they have like up to standard double glazing windows and such?
They are, which is very close to here. The ones directly behind are 2 stories high, 4-bed family houses, so children could be living there, and they are, say, just 15 metres from the garden or their courtyard, so children could be playing in there, and they're 15 metres from the back of a courtyard.
Okay, how old is the property?
Those properties will be there about 8 or 9 years, perhaps 10 years.
Okay.
And interestingly, it was mentioned that farther down, the licensed premises farther down, I had a job to sell those houses because they're at the back of pubs. A lot of people wouldn't live there because they were there. I built them because that was the project to regenerate the area. But the pubs were already there. They've been there a long, long time. So people who bought knowing they're living at the back of a pub. And also, it was farther away.
Okay.
Well, this is different.
Okay, thank you.
Okay.
Thank you very much, sir. Who's next, please?
Hi, my name's Anthony Wolfson. I live in Moat Lane. My issue with it in particular is around the use of the courtyard, particularly because the courtyard, first of all, my personal property, such as my car, currently actually blocks the gate to the rear of that courtyard to the point of inches. But I'm also, the point I wanted to make was I'm an ex-police sergeant with the City of London Police, and I worked with licensing and with antisocial behaviour when it came to the use of alcohol. I did 10 years with the City of London Police, and I saw firsthand some of the issues that happen with members of the public, and of course the use of alcohol and damage to property and all the rest of it that can be associated with the use of alcohol. My concern particularly is that, first of all, the fire, if there was a fire escape there, there's no way anybody could actually get out of the gate at the moment because I own the car parking space, and my car is, as I say, literally inches away from exiting. And secondly, the potential for people that are in that courtyard, not just for the sake of the noise that Colin's highlighted, but also people when they're drinking in courtyards can often have debris such as cigarettes or bottles or glasses or anything else that can end up perhaps going over the wall or being put against the wall or anything like that, and that can damage personal property. So I'm not only concerned about the noise, but I'm also concerned about actually the use of people so close to property as it stands at the moment with that courtyard. And that's really my main points.
Does anyone have any questions?
Yeah, it's not directly associated with this premises here, but just in the general area, there's a nearby pub located. And any response from the police, and any trouble that goes on down the road there, you should think that'd be different to this location?
No, I mean, I'm not a serving police officer at the moment. I just want to make that I'm an ex-police sergeant with the City of London Police. But I know from conversations that I have with police colleagues that are in Northampton Police that there has been incidents in and outside the Brave Old Oak recently, for example, that one in particular. I know there's been incidents there on the High Street, not the back, but at the High Street side.
Okay. I think you also raised in your original email about about security of the gate at the rear of the parking space that you discussed. Could you elaborate a little bit more on that?
Yeah. So you know the issue is the gate at the back there is an old gate that's not secured. If it was, you can't exit the gate because my parking space that I own with my property, as I said, it's inches away from the gate, so you can't actually, somebody would have to squeeze past the car in order to get out of the courtyard. So there's the worry about damage to my personal items and belongings, and also if that gate was secured so that people couldn't exit it, then presumably we've got an issue with a fire escape because people couldn't get out that way.
Okay.
So,
Thank you.
Okay, thank you very much, sir.
Thank you.
Sorry. Good evening, everybody. My name is Peter Nicol. I live in the Moat Lane development at number 27. This development, as you probably are aware, is in a conservation area, and as the map shows, it is mainly, it is largely residential area. I have some concerns about, the definition of a conservation area. To me, it's more than just restrictions made to types of building. Surely it's about conserving the whole environment and making it maintaining the ethos and the calm that Colin has described. My property is approximately 20 metres from the proposed courtyard, directly at the rear of 130 Watling Street. As you know, the plans for the cocktail bar include a courtyard where customers will be drinking, smoking and listening to music through outdoor speakers. I will be able to see and hear all of the activities taking place within the cocktail bar. The planning application states that the bar is, as you've heard from Nikki, the hours opening time is goes to 12:30 sometimes. I just wonder whether there is any, on the planning application, the bar is open from 12 till midnight. I just heard there's been an extension to allow drinking up time to 12:30, with the music stopping at 11:30. And this goes on for 7 days a week. Can you imagine living in a property 20 metres for this that goes on, 7 days a week, 365 or 364 4 days a year. I have two objections to the application for the cocktail bar. Firstly, the provision of a site selling alcohol and providing music so close to a residential property is, in my opinion, totally unacceptable. Again, if you knew the area, the architecture of the buildings on Watling Street are their high pre-war buildings, and there is no opportunity for noise to dissipate. We live in an area where the church is off to the south, but we hear the chimes of the bells, which are very pleasant, and at appropriate times onto the north, because it just bounces off the buildings, and I'm concerned that the noise is, because it's such a built-up area, will not have an opportunity to dissipate. My other main objection is the length of time that the cocktail bar is going to be open, and the lateness of its closing time. I've had communication with Mr. Sorry, I forgot your name. About the external loudspeaker, and it will only be providing background music, but an outside speaker playing until 11:30 at night, so close to residential properties, to me seems strange. And I just wonder, are there not any local or national regulations concerning noise pollution? I know I've lived in areas in the past where the pubs have had to stop turn off their music a lot earlier. Anyway, I object to the bar being open for the 7 days for 12 days a week, and this will give my wife and I no respite from the noise and inconvenience. It will have a really significant impact upon the quality of our lives. Thank you.
Thank you. Any questions?
Okay, thank you.
Thank you very much, sir.
I'm not sure I need a microphone. I have a loud enough voice. I'm David Simmers. I live in Tinsmith Cottage, and I also own a small property called Trinity House, which is 126 Watling Street. I'm a little surprised that we haven't actually had any notification through the letterboxes or anything about this application, and I wonder whether or not some of the other properties here marked even know that this discussion's going on. I only heard about it by word of mouth. Very few of us living in that area walk down that particular piece of Watling Street because we go round it. So I'm just wondering whether or not the residents are fully represented here anyway. Sorry, you look as if you're about to say something.
I was only going to say that as part of the legislation, every premises licence application that is submitted has to put up a blue notice at the actual premises itself.
Yes,
So-
I'm just
and
saying
that was
nobody walks
displayed.
past that particular
Yeah.
thing, so the residents round the back of it haven't actually been told about it. I live about 12 metres from the side wall of our house to the rear of that garden, but no, I don't have any windows in it either. But principal concern is the courtyard itself and the noise it generates. As Peter said, the noise bounces round off these buildings at the back, and it magnifies in doing so. You're getting double sounds all the time, and that is really going to be very annoying with the noise that an outside drinking area does create. It doesn't matter how much you say, oh, it'll all be very quiet. We know that it'll be noisy. We know that also that if the planning application for it goes through, in 5 years' time, it might not be the same people running the bar. We may, in fact, have a very much noisier operation going on in there. And it is a long-term view here about the planning as well. I personally don't think the courtyard, don't worry about the building itself. They can shut the windows and the doors and the noise will go down at the front. The courtyard should not be used for a drinking area or any music, never mind what the time is. People are in their residence all day, and a lot of them actually go to bed about 9 o'clock at night, not 11 o'clock at night. It's far too late. Even if you allow any time on the music, 11 o'clock is far too late. And that's my principal problem. I'm probably echoing a lot of things that have already been said, but yeah, another objection. It shouldn't be allowed to happen in the courtyard at all. Okay.
Thank you. Anyone have any questions?
No questions.
No.
Okay. No. Thank you, sir.
Good evening, everyone. My name is Brian Ball, and I'll apologise in advance for the Scottish accent. I'll try to be as comprehensible as possible. My wife and I live in 29 Moat Lane, literally 21 paces from the back of the building we are discussing here this evening. If the building had been a licensed premises when we bought it, we would not have bought it. My strong objections appear in the appendices of today's agenda on pages 39, 40, 41, 44, 45, 48, 55 and 56. I obviously do not have time to repeat them in detail this evening, but will of course answer any questions you care to put to me. I lodged my objections with the licensing department via the official channel, highlighted by the small announcement in the window of the former Lloyds Bank. I lodged them again with the appropriate department when a similar notice appeared requesting comments on the proposed change of use. One of the frustrations inherent to this process is the tendency for each department to refer to the other, so I have repeatedly been left in limbo as one department says my points refer to planning rather than licensing, and vice versa. To this layman, the issues are intimately intertwined. Another is my inability to understand why there exists a presumption in favour of granting an application from one interested commercial party when several other interested residential parties object. I simply don't understand why there is that presumption. Returning to the core discussion, the proposal to licence the premises for the sale of alcohol and provision of regulated entertainment from 11 a.m. till midnight, 7 days a week. If one allows for opening preparation time of an hour each morning and clearing up time of an hour at the end of the day, that means disturbance for around 105 hours out of 168 in a week, at least. My reaction remains a combination of disbelief and utter dismay at the prospect of wholesale destruction of the peace and quiet that exists in Moat Lane. My wife and I both fear for our mental well-being and have already discussed at length and with some bitterness the impact the proposal is already having on our lives. The alternative of moving elsewhere appears increasingly often in those domestic exchanges. We are potentially severely affected by this. As Colin Clayson suggested earlier, come and visit us. See how close we are to the source of likely disturbance. And I think you will form an inkling of why we are devastated at learning of this wholly inappropriate proposal. I urge you to reject this ill-considered application, consign it to the dustbin of local licensing history, where it well and truly belongs. Thank you for listening.
Thank you. Anyone have any questions?
Yeah, Mr. Bullen, I noticed you've raised obviously a few concerns. Obviously, a lot of these were addressed with an amendment. Do none of those appease you at all?
Well, I don't consider extending the licensing hours till midnight. I don't consider that some kind of considered reaction to a strong objection about the existence of the licensing hours at all. They don't appease me, no.
Okay, thank you.
But I'm not easily appeased.
Anyone else? Thank you very much, sir. Okay, any questions from the licensing officer? Any questions? Okay. I'd like to ask you, sir, if you would...
Hello, my name is Steve Carthy. I'm a fellow of the British Institute of Innkeeping, and I'm here to help Anthony just represent his case. First of all, Anthony is a very well-respected local businessman. He runs the Watling Street Village, which is much bigger premises, with a huge garden with residents either side, and has had no issues with noise and makes sure that everything is run correctly. And he's very experienced. He's going into this trying to build a business, but it's going to be a premium cocktail bar. It's not going to have any draft beer. It's not going to be lager driven. It's not going to be youngsters. It's going to be nicer people with a more disposable income that want to just sit and chat and have a nice drink and somewhere to have maybe some olives and a cocktail. He's worked already with the authorities and has made some concessions. We are also going to give more concessions. We are asking for the removal of recorded music outdoors and live music for the whole of the venue to try and work with the residents to appease them and make sure that we're not going to give a lot of noise out. We're very aware of the courtyard and the gate at the rear, and that is being dealt with by the planning committee, which is on the 22nd. We're also aware of noise, and as I say, Anthony runs the Watling Street Village, which has a huge garden and has a capacity for over 120 people in the garden alone, and has had no issues. So this courtyard is much smaller, probably only hold about 20 people once there are tables, etc. in there, and like I say, a nice clientele, so we don't envisage any more than background noise. We're also going to train staff to use a decibel meter and monitor noise levels from sort of 10 onwards every half an hour or so throughout the week to make sure that noise levels are kept in a respectable level. Anything else?
I think that's it.
I think that's it, really. You know, he's just very experienced, responsible, and runs a responsible business now, and I don't see that changing.
Thank you. Anyone have any questions?
Yeah, regarding the front access to the building itself, were vehicles parking and things like that, and there's no off-road parking. It's probably nothing much to do with relation to this, but with the footfall sort of thing, how busy is it likely to be at peak hours of weekend?
So capacity inside is approximately about 40 people. That's sitting and standing. There is a large car park in Toaster, which is a few minutes walk from the premises. It's been agreed with EHO that any deliveries would be through the front, bins would be emptied out the front, and I've been in contact with West, with the council, with regards to the emptying of bins, and their risk assessments for the business are in place, and it won't affect traffic on the high street. There is no car park, but it's on High Street. A lot of people walk into Toaster, from my experience working at the Watling Street Village, or taxis, to be honest with you.
Okay, and you confirm that there's going to be no recorded music in the courtyard?
Yeah, so the recorded music will be indoors only, not in the courtyard, and live music for the whole building. I wish to remove that from the application. Although it was agreed with EHO, it would be Fridays and Saturdays only, and the courtyard would be closed during that interval, due to the number of times that I was potentially planning to do live music, which would be for events such as Christmas, bank holidays. It would be a small solo singer, someone playing a keyboard, a special theme night, cocktail cheese night. It wouldn't be a band, but I'd rather move the application to address some of the concerns around live music.
Okay, thank you. No more for me.
Any questions from the licensing officer?
No.
Any questions from the objectors? No.
Just to be clear, that is music. So there's no music in the courtyard.
No music.
No live music.
No live music
live
and no
music.
Recorded music in the courtyard.
In the courtyard. And no live music in the whole building.
Okay, thank you very much. All parties now have the opportunity to sum up. Would you objectors like to sum up your objections, or are you content with what you've got? You don't need to go through it all again.
No, but I think that the fact that we have 4 residents and myself as the builder here, and many more people have asked me, that's why I'm here. People have spent their money, bought the house in good faith in a residential area. As I say, if they'd known a bar is going to be there, they wouldn't have bought. So I think it's very important you know how much this bar will affect all the residents. And you know and let's say if it's in a year's time or 2 years' time, if you grant a licence, who's not to say, well, the gentleman sitting in front of me, or if it doesn't work out, somebody else comes along and says, well, yeah, we've got a licence, now we'd like to have live music, and you can reapply for that later. The whole point is it shouldn't be a licensed premises. We're not objecting to any other uses, it's just because it's right on top of a residential area and it shouldn't be there. But anything else, you know, we don't have no objections.
Thank you, Mr. Clayson. Yes, sir?
Just echoing what Colin has just said, I think comparing long-established licensed establishments like the Plough, the Rice Bowl, and the other one, the Brave Old Oak, I think comparing them to a former bank becoming a licensed premises is disingenuous. If it were like for like change, I don't think any of us would be objecting, but I don't think you could have a more unlike like change.
Thank you. Would you like to sum up anything from what you've heard?
No, we're okay, thank you.
Okay. Thank you very much. Okay, can you sum up, please? On this? You're with nothing? Oh, okay, thank you. Have you had sufficient time to say what you want to say? Excellent. Thank you. Okay.
Sorry, Mr. Chair, can I ask a question? What is the relationship between this hearing and the change of use panel in a week or two's time?
This is a licensing committee, sir.
Yeah.
We deal with the actual license for the premises, for the alcohol, music, that. The other committee is the planning committee, which deal with the building and the usage that they can allow.
Right.
Does that make sense? Is that? Yes, sir, please, yeah.
Yes, so the two regimes are independent of each other and they must be kept separate. There's provision for planning authorities to be responsible authorities for the purposes of the Licensing Act 2003. However, in this case, no relevant representations were submitted by the planning authority, so the two regimes are separate. So planning considerations can't be taken into account in relation to the licensing process and vice versa.
So you could have two different outcomes?
That's correct, yes.
Okay, ready enough time? Nothing else you want to add on to that? No. Okay, thank you all for your attendance. The subcommittee will now retire to make our decision. Decision of the subcommittee will be made within 5 working days of this hearing, and the results will be communicated to all parties forthwith. And details of how to make an appeal against a decision of the subcommittee will also be included with that result. Thank you very much for your time.
Thank you.
Can I pinch one of your maps, Colin?